Okay, so now we go to documentary evidence. There are two categories of documents as evidence. So you have documents as writings. So examples of this are contracts and wills. And then second, any other material containing modes of written expression, not traditionally considered as writings, but are actually objects which contain modes of written expressions. For example, billboards. Okay? So they are not generally considered as documents yet because they contain modes of written expressions. They are considered documentary evidence. Printings on a shirt. Okay, since they contain modes of written expressions, then they may be considered as documentary evidence. Okay, under the amended rules of evidence, sounds, drawings, and X-rays are may also be considered documentary evidence. Okay. Now, question: in so far as object and documentary evidence are concerned, suppose the witness testified in court that while hindi ko, so this is the testimony of the witness in court, hindi ko po nakita yung mukha ng perpetrator. Hindi ko nakita yung mukha ng perpetrator, pero may nakita ako na tattoo sa right hand niya. And that tattoo was a dragon. So question, can the court compel the accused to show his right hand to see whether or not he has a tattoo? Or suppose the accused has a tattoo, pero hindi nila alam what's the print. May the court compel the accused to show his tattoo on his right hand or right arm? Doon naintindihan ninyo? So, witness testified in court, hindi ko po nakita yung mukha ng perpetrator, but I was able to see his right hand, and his right hand has a tattoo, a dragon tattoo. So during the hearing, the accused was wearing a long sleeves. May the court can the court compel the accused to show his right hand to verify whether or not he has a tattoo? Or suppose the accused has a tattoo. May the court compel the accused to show his tattoo on his right arm? Yes or no?
Hello po, attorney. Yes po, attorney.
Does it not violate his right against self-incrimination?
No po, attorney, because right against self-incrimination will apply only on testimonial evidence po, attorney, or on purely testimony po.
And so why is that right not applicable to our given scenario?
Because po, attorney, in the given
What
scenario,
kind of evidence is involved? Kasi you're saying the right against self-incrimination is applicable only to testimonial evidence. So what kind of evidence is being presented here?
In this situation po, attorney, the tattoo on the arm is being presented as a object evidence because it is presented to the senses of the court po, attorney.
So when you say it is presented to the senses of the court, what does that mean?
It means, attorney, that the evidence must be presented to the court as is, and the court will evaluate the evidence being presented by the use of its senses. In this case is
What are the senses? What are the 5 senses?
sense of sight, smell, hearing, touch.
So you have sight,
Hearing, taste, and touch.
smell, and touch.
Yes po, attorney.
So the tattoo on the accused's right arm, you are presenting the evidence and addressing it to the senses of the court, specifically the sense of sight,
Yes po, attorney.
for the court to observe whether or not whether or not the accused has a tattoo. That's one. And if he has a tattoo, whether or not the tattoo on the accused's right arm is a dragon.
Yes po, attorney.
Okay?
Yes po.
And that evidence, the tattoo on the right arm of the accused, is not a testimonial evidence. It's an object evidence. Since it is considered as an object evidence, the right against self-incrimination is not violated. And since the right against self-incrimination is not violated, then the court can compel the accused to show his right arm to verify whether he has a tattoo and whether or not his tattoo is a dragon. Okay? So, therefore, the accused cannot refuse the court and invoke his right against self-incrimination. Okay. So when is a document? So I have a contract of sale. Okay. I have a contract of sale. So it is a civil case and it is a breach of contract case. Specifically, a breach of contract of sale case. Okay. Now, I have a contract of sale. What kind of evidence is a contract of sale? What kind of evidence is a contract of sale in relation to the breach of contract case? So it's a civil case, right? Specifically, a breach. So the cause of action is breach of contract of sale. Now, I want to present the contract of sale as evidence. So what kind of evidence is the contract of sale? Miss Cruz, what kind of evidence is the contract of sale?
In the breach of contract, the contract of sale may be classified as documentary evidence.
Is that your answer?
Yes, po.
So when you say may be classified as a documentary evidence, what does that mean? Kasi diba I'm asking you, how will you classify what kind of evidence is the contract of sale?
Since it's written notes, it will be considered as documentary evidence.
So is considered. It is considered or it may be considered. What is your... Kasi magkaiba yung meaning.
It is considered.
It is considered as a contract of sale? As
It is considered as
documentary evidence? Miss De Corania, do you agree with Miss Cruz that so in a breach of contract case, a contract of sale shall be considered as a documentary evidence?
Yes, attorney.
Do you agree with her?
Yes, attorney.
Miss Gakutan, do you agree with Miss Cruz and Miss De Corania that in a breach of contract case, a contract of sale shall be considered as a documentary evidence?
Yes po, attorney.
Miss Gutierrez, same question. Where is she?
No part here,
Yes, Miss Gutierrez.
Yes po, I haven't started.
That a contract of sale is a documentary evidence?
Yes po.
Miss Aldion, do you agree with your 4 classmates?
No po, attorney.
Why not?
Since it is a contract of sale po, attorney, and the contract itself, it is the very object po, attorney. So, it is considered an object evidence po, attorney.
So, your answer is that it is not considered as a documentary evidence but an object evidence. That's your answer?
Yes po, attorney.
Miss Larcena,
Yes po, attorney.
when is an evidence considered a documentary evidence under the rules of court?
It would be considered as a documentary evidence if its contents are the subject of the inquiry, attorney.
If the subject of the inquiry is the content of said document, or if it is offered as, if the document is offered as proof of its content, right?
Yes, attorney.
In the scenario that I have given, or in the example that I have given, it is a breach of contract case, and I want to present the contract of sale as evidence. What kind of evidence is the contract of sale?
Attorney, if that is the original document,
It is the original document. Hindi issue yon. It is the original document.
yes, attorney.
So what kind of evidence is the contract of sale?
It would be the best evidence, attorney, to present.
Best evidence is that rule. So if you are applying the best evidence rule or now the original evidence rule, then you are considering the contract of sale as a documentary evidence because that rule is only applicable to documentary evidence, diba?
Yes.
Do you agree with your 4 classmates? And you don't agree with Miss Albion that it is not a documentary, that contract is not a documentary evidence but an object evidence. Ang sabi ng 4 na kaklase mo, that contract is considered a documentary evidence. Ang sabi naman ni Miss Aldion, no, it's not a documentary evidence but an object evidence. So, my question is, what kind of evidence is the contract of sale? Kasi sabi mo, an evidence is considered a documentary evidence if the subject of the inquiry is the content of the document, or that document is being offered as proof of its contents, right? So, you have a contract of sale, documentary and testimonial. Definitely not testimonial, so dalawa lang yung pagpipilian mo. Apat na yung nagsabi na documentary evidence. May isang nagsabi na object evidence. So, how about you? How will you classify the contract of sale? Will you classify it as object or will you classify it as documentary?
Attorney, in that given case, is it written, attorney? If it is written,
Yes, a contract of sale. It is, I want to present the written contract of sale in evidence. So how are you going to classify it? Will you classify it as a documentary evidence or as an object evidence?
it would be a documentary evidence, attorney.
So we have 5. 5:1. So 5 saying documentary evidence, 1 saying object evidence. Mr. Bajal,
Bahal, attorney.
Bahal.
Opo.
Oh, same question.
Attorney, the document will be the contract of sale will be considered a documentary evidence, attorney, because it is a written document presented to prove what is written in it, attorney.
Miss De Vera. Where is Miss De Vera? Where is our beadle? Is our beadle around? Oh, there it is. Miss De Vera. Where is she?
Nag-CR daw po, attorney.
Mr. Soriano. Same question. What's your answer?
In this scenario, attorney, I would agree with Ms. Aldeo that the contract will fall under object evidence because under the section 2 of Rule 130, if it is presented in other purpose or when a contract is presented before the court, it will be considered as an object or real evidence, attorney, because a contract, it contains letters, numbers, or other elements that may deem it as documentary evidence. But in this case, the contract is presented before the court and it will make the evidence as an object or real evidence rather than a documentary evidence, attorney. So it will be an object or real evidence.
Okay, so what can I gather from your answers, ha? So you have a document. A contract of sale is a document, right? So not because it is a document, it will be automatically considered as a documentary evidence, right? A document may be considered as a documentary evidence, or it may also consider as an object evidence. So not because, so it's not correct to say that a document is a documentary evidence, is classified as a documentary evidence always, because a document may be considered as an object or a documentary evidence. So when is a document considered as a documentary evidence? If it is offered as proof of its contents. Okay, so in our instant case, in a breach of contract case, if the contract of sale is being offered to prove that the buyer failed to comply with his obligation as is stated in the contract of sale, then the contract of sale is a documentary evidence. Why? Because the contract of sale is being offered as proof of the contents, meaning obligations of the, ano ba yung contents ng contract of sale? Obligations of the buyer. For example, if under the contract of sale, the buyer must pay the purchase price within 30 days from the execution of the contract, and the buyer failed to pay the purchase price. So you will present the contract of sale to prove that the buyer did not comply with his obligation under the contract of sale. If that is the purpose of you offering the contract of sale, then that contract of sale is considered a documentary evidence. Okay? Because you are offering the document, the contract of sale, as proof of its contents. However, if you are merely offering or presenting the contract of sale to prove execution of the contract, to prove that buyer and seller has executed a document, and that document is a contract of sale, how will you classify the contract of sale? You don't classify that as a documentary evidence. If that is your only purpose of offering the contract of sale, then the contract of sale is not a documentary evidence, but an object evidence. If you are only offering the contract of sale to prove execution of the contract, then it has nothing to do with the contents of the contract, then it is not a documentary evidence, but an object evidence. Do you get the distinction? When is a document considered documentary? When is it considered as an object evidence? The same with photographs. A photograph may be considered as a documentary evidence, or it can also be considered as an object evidence. Okay, so when is a photograph considered an object evidence? Give me an example wherein a photograph serves as an object evidence. Picture of the injuries. Kasi diba, when you figure in an accident and you want to document the injuries that you have suffered, diba, pipicturean ninyo yung injuries? For example, yung injuries that you have suffered, or the damages that your car has suffered, diba, you take photos of the wreck, or you take photos of your injuries. Those photographs, if those are presented in court, what kind of evidence are those photographs? How will you classify those photographs? Will you classify those photographs as documentary evidence, or will you classify them as object evidence? To show damage, to show your injury. So you will present photograph, diba, you took photos of your injuries that you sustained from the accident, right? So you want to present those photographs of your injuries in evidence. So how will you classify that? How will you classify the photographs? Will you classify the photographs as object or documentary? Miss De Vera, how will you classify the photographs? Will you classify them as object or documentary?
I would classify them as both since the definition under the rules of court is that as to the object evidence is to address to the sentence of the court. So to exhibit, of course, to have visual representation attorney, you could provide now the photograph as object or real evidence in the case. So I would also classify that as a documentary evidence since it would show some like scene of the crime basically, and then since po sa case given that tama po attorney na may aksidente, so it would reveal the condition of based on the photograph. So I would classify them as both object and documentary evidence.
Why? Are you offering the photographs as proof of their contents? You're not, diba?
No, yeah, I mean, of course, attorney, there should the photograph itself do not provide contents if we are speaking of.
There is, okay, stop right
writing.
there. No, stop right there, Ms. De Vera. Okay? That's why I asked Ms. Larcena kanina, when is an evidence considered a documentary evidence? Kasi, if the subject of inquiry is the contents, is the very contents of the evidence, or it is being offered as proof of their contents, then the evidence is deemed documentary evidence. If offered for any other purpose, then it is an object evidence. You are offering the purpose of you presenting the photographs in court is to show the extent of the injury that you have sustained in the accident. That's your offer. So how will you classify the photographs? Will you classify them as object or documentary?
Now, attorney, it would be classified as object evidence since as to the relevant to the fact and issue. The court now from that photograph may examine already the like some sense of sight of the fact and issue po.
Because they are the evidence because the photographs are presented to address to the senses of the court, specifically for the court to see the extent of the injuries that the victim sustained. So the photographs now is not considered, the photographs are classified not as documentary evidence but object evidence. Why is that important? Kasi there are rules that are only applicable to documentary evidence. Okay? That are not applicable to object evidence. For example, like what Ms. Larcena mentioned kanina, the original evidence rule, the best evidence rule now, the original document rule. That is only applicable if the evidence involved is a documentary evidence and finds no application to object evidence. So para malaman ninyo whether the evidence is deemed an object or documentary, ano ang titingnan ninyo? You're going to look at the offer. Because the offer contains the purpose. Why is the party presenting that evidence? So you have to look at the offer of evidence. For example, contract of sale. If in the offer of evidence, it is stated that the contract of sale is being offered to prove the execution of such contract, then you know that that contract of sale is merely presented as an object evidence. But if the offer of evidence states that the contract of sale is being presented to prove that the buyer failed to comply with his obligation as stated in the contract, then you know that the contract is being offered as proof of the contents of such contract. Hence, it is a documentary evidence. Since it is a documentary evidence, pwede kayo mag-object if it violates the best evidence rule, now the original evidence rule. You get it? That's why ang titignan ninyo is the offer of evidence, because that will tell you whether the evidence is being presented as an object or as a documentary evidence. Kasi always remember, not because it is a document, it is automatically a documentary evidence. No, look at the offer of evidence para malaman nyo if it is a documentary evidence or it is presented as an object evidence. Same with photographs. Because the rules of court mentioned that under Rule 130, photographs may be considered as documentary evidence, right? So, again, titignan ninyo yung offer of evidence. Para malaman ninyo whether the photographs are being offered as documentary or as an object evidence. Okay, so this is okay. So similar with, di ba, an object evidence also requires authentication. Same with documentary evidence. Documents must be authenticated before they are admitted in evidence. Okay. So why is authentication necessary? Because it establishes authorship, execution, and genuineness of that document. Okay, so original evidence rule. This is formerly known as the best evidence rule. So what is the original evidence rule? Okay, so when the contents of a document are in issue, meaning the document is being presented as a documentary evidence, then the original document must be produced. What is the purpose of this rule? The purpose of this rule is to prevent fraud and ensure accuracy. Okay, so if the original is unavailable, secondary evidence may be admitted under specific circumstances as stated in the rules of court. Okay, so the original evidence rule applies only when the contents of a document are in issue. So as I've said a while ago, this rule is only applicable to documentary evidence and finds no application to any other evidence. So always remember, applicable lang siya sa documentary evidence. Okay. Example where it applies: a contract dispute over the exact wording of a clause because the contents of the contract are in issue. Hence, the contract is deemed a documentary evidence. Since it is a documentary evidence, then the original evidence rule applies. So example where it does not apply, where this rule does not apply: a witness testifies, I saw the accused sign the contract. So the contract, here the witness is testifying about an event, specifically the execution execution of the contract. Hence, the original evidence rule does not apply because it pertains to the execution and has nothing to do with the contents of the contract. But, if ganito yung testimony ni witness, the contract states that this buyer must pay the purchase price within 30 days from the date of execution. Will you apply the original evidence rule? Yes or no? The witness testifies the contract provides that the buyer must pay the contract price within 30 days from the date of execution. Will the original evidence rule apply? Yes or no? Yes or no?
Yes po, attorney.
Why?
Because you are proving
The witness is testifying as to the contents of the document, right?
yes, the terms of
The contract now becomes a documentary evidence, and since it is now considered as a documentary evidence, the original evidence rule applies. Okay? Which is different from the testimony of the witness kapag sinabi niya lang, I saw the accused sign the contract. Since the witness is merely testifying as to the execution of the contract, then the contract here is not a documentary evidence but an object evidence. Since the contract is considered an object evidence, original evidence rule finds no application. Okay? So you cannot object kapag si witness nag-testify lang, I saw the accused sign the contract, and then can you raise your objection? Objection, Your Honor. Original evidence rule. Can you raise that objection? You need to present the original copy of the contract. Can you raise that objection? What do you think will be the ruling of the court? Will the court sustain the objection or will the court overrule the objection?
Sustain po.
Sustain?
Will overrule po, sir.
Ano bang ibig sabihin ng sustain? Anong ibig sabihin ng overrule? Kapag the objection is sustained, what does that mean? Di ba kasama siya sa slide? Right? Sa bandang dulo. If the objection is sustained, what does that mean? If the objection is overruled, what does that mean?
If the court ruled, if sustained po, attorney, the court grants the motion or the objection. If the court ruled overruled, the court denies the objection po, attorney.
Also, look at this. The witness is testifying. Ito yung testimony ni witness. I saw the accused sign the contract. Objection, Your Honor. Original evidence rule. The original copy of the contract must be presented in court. So, Mr. Sanchez, if you were the judge, how will you rule on the objection?
Overruled po, attorney, because the objection of the counsel is not proper, being the evidence is being presented as a object evidence, not a documentary evidence. Hence, the application of original evidence rule will not apply po.
Okay, so tatawanan ka ni judge. The judge will know that you don't know what you're talking about. Okay? So the objection will be overruled. because the contract here is being presented as, because the witness is merely testifying as to the execution. Since it only pertains to the execution of the contract here is just an object evidence, not a documentary evidence. Hence, the original evidence rule finds no application, does not apply. Okay, so take note of this new ruling, wherein a photocopy is admissible in evidence to the same extent as the original. Therefore, the photocopy is no longer considered as a secondary evidence. Okay? So in People versus Lastimosa, the Supreme Court, through Chief Justice Jesmundo, ruled that a photocopy is admissible in evidence to the same extent as the original, as long as there is no genuine question about the authenticity of the original, or that its admission would be unjust or inequitable. This is a landmark ruling. Okay? So it has overturned the previous court rulings, which says photocopy is merely a secondary evidence. Okay, so here are the exceptions to the original evidence rule. Okay, so you can find the exceptions in section 3, rule 130 of the rules of court. Okay, let's start with the first exception. What's the first exception? When the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offeror. So, ibig sabihin, the original evidence is not available, right? So, you want to present secondary evidence. So, how will you lay down your basis so that the court will allow you to present secondary evidence? So, first is to lay, kasi you have to lay down. Kasi if you are going to claim, so basically, if you are going to claim exceptions under section 3, rule 130 of the rules of court, you have to lay down first your basis. Meaning, what exception are you claiming before the court can allow you to present secondary evidence? So if you are invoking the first exception, meaning the original has been lost or is destroyed, so how are you going to lay down your basis? So first is, the offeror must first prove the existence and the execution of the original document. Of course, you have to prove first that the original document previously existed. Okay, that's the first one. Second one is that the second step would be the offeror must show the cause of its unavailability, such as the loss or destruction of the original. So first you have to prove the existence and execution of the original document, right? Second step is to prove, to show the cause of why the original document is unavailable. And what is the reason for that? Because it has been lost or it has been destroyed. What's the third step? The offeror must show that the unavailability was not due to his or her bad faith. That's how you lay down your basis para payagan ka ni judge to present secondary evidence. Okay. So, how do you usually do it in court? Is it enough for you to say, Judge, I would like to manifest that that the original document has been lost, and I would present this evidence as substitute. Is that enough? Enough? Sabihin ninyo kay Judge, Judge, I would like to manifest that the original of the document has been lost, And I would like to present this evidence as substitute. Is that enough? Para payagan ka ni Judge to present secondary evidence? Yes or no?
No po, attorney.
Why not? So how are you going to do it? If mere manifestation is not enough, if so how will you do it? Kasi 'di ba alam mo na kung ano yung how you have to lay down your basis, right? You have to prove the existence and execution of the original document. You have to show the cause of the original documents and availability, such as loss or destruction. And lastly, you have to show that the unavailability was not due to your bad faith. So mere manifestation is insufficient. It's not enough. So how
Yes po.
will you do it? So you have to present a witness. You need to present a witness. Mere manifestation is not enough. You have to present a witness, and that witness will testify on the existence of the original document, that the original document has been lost. So sabihin niya nawala po kasi paano nawala yung document? Kasi lumipat po kami ng bahay or nabaha yung bahay namin, to establish that the original document has been lost and that the unavailability was not due to the offeror's bad faith. That's how you do it. You have to present a witness. You don't just manifest before the court na, Judge, nawala po kasi yung original document. Kaya ito lang yung, ano yung pwedeng i-present nila. Kaya ito lang po yung mai-present namin. Kaya hindi namin ma-produce yung original document. You can't do that. Okay? Mere manifestation is not enough. Okay. Suppose you were able to lay down the basis that there exists an original document and that original document has been lost and the loss was not due to your bad faith. What will be the secondary evidence that you may present in lieu of the original document? Mr. Angeles, what secondary evidence can you present in lieu of the original document?
Attorney, anything po, attorney, that
What do you mean? You can just say anything.
after establishing that the original document that are lost.
Yeah, you were able to establish that there exists an original document, that the original document has been lost or was destroyed, and that the loss was not due to your bad faith. You were able to do that. Now, you will present a secondary evidence. Kasi di ba wala kang original document. So you will now be allowed to present secondary evidence. My question is, what secondary evidence can you present in lieu of the original document? You can just say anything.
Following the hierarchical order po, attorney, I will first present the photocopies or Xerox copy,
Of
attorney.
course, if you have the photocopied and that's no longer applicable kasi photocopy is considered following the doctrine in People versus Lastimosa, right? Photocopy is now considered as original. Oh, okay, photocopy. So, if wala kang photocopy, what's next?
The duplicate originals, attorney, or the carbon copies.
Eh di, may original ka nga. If you have duplicate copy, then you have the original. Nawala nga yung original, right? Wala ka nga original document. The documents that you are saying, those are considered original document. If there exists a duplicate copy, then you can't invoke, you can't claim exception. The original evidence rule applies to you. Right? Right, Mr. Angeles?
Yes po, attorney.
Nasa exception tayo, right? Wherein ibig sabihin, original documents are not existing anymore because they have been lost. Tapos sasabihin mo ako na you will present photocopy and you have People versus Lastimosa saying photocopies now are considered original document, are admissible to the same extent as the original. Sasabihin mo ako ng duplicate copy. Under the rules of court, duplicate copy is considered an original copy of the document. An original document. What are the... Kasi diba, you have section 3 of Rule 130. Section 3 of Rule 130 provides for the original evidence rule. First paragraph of that section provides for the original evidence rule. So what is the general rule? You have to present the original of the document, right? And what are considered original, Mr. Angeles, under the rules of court? What are considered original under the rules of court?
Original document, attorney, an original document is a document itself or any counterpart intended to have the same effect by a person executing or issuing it. Original of a photograph, attorney, includes the negative or any printer from. Includes the data stored in a computer or similar device, and printouts or other output readable. And that's shown to reflect the data accurately. It is considered an original document.
How about
Also,
duplicate?
the duplicate, attorney, is produced by the same impression as the original. And for example, the carbon copy, attorney, which made simultaneously.
A duplicate
So
is admissible to the same extent as an original. Same with photocopies, right?
Yes,
So
po.
ibig sabihin, before you can claim exception under Section 3, Rule 130, ibig sabihin, all of those are not available. Meaning, walang photocopy of the document. Walang duplicate copy of that document. Because otherwise, why are you claiming exception if you have duplicate copy? Because that duplicate copy is admissible to the same extent as an original. So what are the possible secondary evidence that you can present if the original document has been lost, Mr. Angeles?
If the original document has been lost, attorney,
imagine, class, you imagine a scenario wherein the original document has been lost. Because, so if the original document has been lost, then you can comply with the original evidence rule, right? Diba? For example, it's a breach of contract case, in our breach of contract case. And there was a breach of contract because the buyer failed to pay the purchase price within the stipulated period. Okay? That's why the seller sue the buyer. Oh, that's our scenario. The seller sues the buyer because the buyer failed to pay the purchase price within the stipulated period, or within the period stipulated in the contract of sale. But the problem now here is that the contract of sale has been lost. Okay? Nawala yung contract of sale. Nawala yung original, the one that, nawala lahat. Duplicate the original, the duplicate, as well as walang photocopy ng contract of sale si seller. As a general rule, since the issue at hand is the content of the document, the seller must comply with the original evidence rule, right? And must present the original document. But ang problem ni seller is that the original document has been lost. So ano yung remedy niya? Mr. Angeles, what's the remedy of the seller?
The testimony of the
What's the
witness
remedy
attorney.
of the seller? The remedy of the seller is to claim exception under section 3130, right? Specifically letter A. Para makapag-present siya ng secondary evidence. So what secondary evidence may the seller present? Testimonial evidence agad, Mr. Angeles? Testimonial evidence agad? Not so fast. If there exists a document wherein it contains a recital of the contents of the document for example, there was a later agreement citing the provisions or the obligations of the buyer in the contract of sale, then that document may be presented as a secondary evidence. Yes, that document is not the contract of sale, but it may be presented in evidence as a secondary evidence if there is a recital of the contents of the document. If you don't have any document containing recital of the contents of the contract of sale, that's the only time. Last resort mo yung testimonial evidence. Why is that? Less credible yung testimonial evidence. It's still admissible, however, it is less credible. Why is that? Why is it considered less credible? Because memory falters, Mr. Angeles. So you don't present testimonial evidence agad. Maghanap ka muna ng other documentary evidence that may serve as your secondary evidence. Kasi it is possible that there may be another document which contains a recital of the contents of the contract of sale. If wala ka talaga mahanap, that's the time na you can present testimonial evidence of a witness who have read the contract of sale, or who has knowledge, a witness who has knowledge of the provisions of the contract of sale. take note, testimonial evidence kapag ang issue is contents of the document, the least credible is testimonial evidence because memory falters. Yes, it is admissible in evidence, but least credible. Okay, suppose you want to claim exception under the second exception. So tapos na tayo sa first exception, right? What's the second exception, Mr. Angeles?
In the original document is in the custody of the or control of the party against whom the evidence is offered. And the latter fails to produce a reasonable notice or cannot be obtained by local judicial processes or procedures.
Okay, so how will you lay down your basis that the original is not available under exception number 2?
First, attorney, I need to prove to the court that I gave the adverse party a reasonable notice to produce the document.
What's the first step? What's the first step that you need to do? You have to prove that the original document has been in existence and was previously executed. So, of course, you have to prove existence and execution of the original document. Always remember that that is your first step. What's the second step?
And after I establish the existence of the document, attorney, I will secondly establish that the document is in the custody of the other party.
That there was notice. Take note, nasa number 2 tayo ha? Nasa number 2 tayo. So, second step is, di ba, first, you have to establish the existence and execution of the original document. Second, there was a notice.
What's
the third step?
The next step is that after being given notice to the adverse party, attorney, the party fails or refuses to produce the document.
That despite due notice, there was failure to produce said document. That's how you lay down your basis.
Yes, po.
Oh, what secondary evidence can you present in lieu of the original document?
What secondary evidence po?
Kasi nawala nga yung original evidence mo, right? Hindi mo nga hindi siya nawala. Hindi mo ma-produce yung original document mo, right? So what secondary evidence are you going to present?
The secondary. The secondary, attorney, yung recital of its contents in some authentic documents po. Ibawa po yung notarized, if the document is notarized po, attorney.
What do you mean? What do you mean if the document is notarized? So if you have a notarized document, but if the original document is notarized, how is that relevant?
Attorney, of the original document was lost in the custody of the adverse party. I can present the basis of the hierarchy of secondary evidence, attorney. A copy of the document or the best substitute. Then the draft copy of the document. The draft copy, which is an unexecuted version that matches the design original po. And if still not available po, attorney, digital copy.
If you claim exemption under number 3, Mr. Angeles, how will you lay down your basis? How will you lay down your basis if you claim exemption under number 3?
Yung number 3 po, attorney, when the original consists of
Yes.
accounts or other documents which cannot be examined in court without great loss of time, and the fact that sought to be established from them is only general result of the whole. To lay down the foundation, attorney, first it must be established that there are voluminous that there must be consist of numerous or voluminous documents po that if examined in court, it will be great result in loss of time po.
Again, Mr. Angeles, first is there are numerous accounts or documents, and what's the second step?
That it would take so much time po to examine the said document po. And after that, after establishing that there are numerous account po, and it would result in the great loss of time. It must also establish that those documents are made available for the defense to check po. Are available in the defense party po.
That's it. Are you saying then, based on how you lay down your basis or your foundation, if you want to claim exception under number 3, are you saying then that the controlling reason why summaries are allowed is because the documents or the records are numerous or voluminous? Is that the controlling reason of exception number 3?
No po, attorney, not the voluminous or not the
But that's what
voluminous
you said. That's how you lay down your foundation.
No, I mean, attorney, not the numerous or voluminous accounts of the document is the controlling reason. What is the controlling reason in the exception number 3, attorney, is the impracticability of examining those documents, because those documents are already available to the defense.
Really?
Meaning, the controlling reason, attorney, is the convenience or the
Is it the
judicial
convenience of
the
judge?
the judicial economy po, attorney.
Are you sure? What's lacking from your answer, Mr. Angeles? You're correct when saying that mere volume is not the controlling reason why summaries will be allowed as secondary evidence when claiming exception number 3, when claiming exception under number 3. But take note, you also need to establish that what you only need is the general result of the whole documents. Look at exception number 3. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result of the whole. This is very important. It's not enough for you to say that, okay, you have numerous, the documents involve numerous accounts, and if the court will examine each one of the pages, it will result to great loss of time. But you also have to establish that what you only need from those documents is the general result of the whole. So example of that, what will be your secondary evidence here? Your secondary evidence would be the contents of those documents or numerous records may be presented in the form of what? Charts, summaries, calculations. So for example, if you only want to present the profit or loss of a company for the last 20 years, you don't have to present all the books from 20 years ago. You can be allowed to present the profit or loss in the form of charts or summaries by claiming exception under number 3. However, if, for instance, the case involved is estafa, and the documents are the subject of the inquiry because they involve fraudulent transactions, then you need to present all your documentary evidence and cannot claim exception under number 3. You get it? And not because of judicial convenience alone. Because you need to establish as well that what you only need from those numerous records and documents is that the general result of the whole records. For exception number 4, the secondary evidence that you may present in lieu of the original document. But first you need to establish the existence of the original document and secure a certified true copy issued by the public officer in custody of said document. Okay, so again, always, yung first step mo before you can claim exception is to establish the existence and execution of the original document. And as secondary evidence, you may present a certified true copy of said document issued by the public officer in custody thereof. So again, here is the summary before secondary evidence is admitted because of the original evidence rule. The proponent must prove the following. First, existence and execution of the original document. This is always your first step. You have to establish or prove the existence of the existence and execution of the original document. Okay? Then you have to show the cause or reason of loss or unavailability of the original document. And lastly, that there exists no bad faith. Ito, it's for the first, yung absence of bad faith, usually that applies to the first exception.